before we move forward?
You need to say something so they can.
Yeah. Hi. If you can hear me, this is Steve Teppler. Good. All right. Thank you very much for showing up. Tom has been very gracious in inviting me to present to you guys. Guys, in the generic sense, please don't think otherwise. And my background is kind of different. I basically trained as a lawyer, then worked on Wall Street for a while, playing with pixels and trading mortgage-backed securities. Then came back to practice, and when my first foray into the technology area was the result of a lawsuit in which we represented a Fair Credit Reporting Act victim. Well, it was an Equifax victim. Before there were data breaches, Equifax made a habit of mixing people's identities up, and unfortunately sent out a background report of our client having a felony cocaine conviction, where really the person who they mixed him up with not only had only a misdemeanor, but it was later expunged. So this was the crime that never was for the person that never was. We won, and I was able to, we had 6 years worth of billing that we were entitled to by statute to get our fees for, and I was one of the first attorneys to keep my timesheets for 3 attorneys on a computer program. So I just basically kept our time for 6 years, and these are pre-electronic filing days, so I filed a 150-page massive tome of paper into federal district court in Washington, D.C. And the first thing that the defendant did, that Equifax did, was dispute our fees, which they were entitled to do. That's normal, it happens. The basis for it was what really was interesting. They claimed that because the printout date on top of the submission was the night before the deadline, they claimed that I had made it all up the night before. And in order to get paid in federal court, you have to have more or less contemporaneously entered timesheets. So $200,000 worth of legal fees that we had to pay later on, we were able to prevail. We went through the entire litigation morass of depositions and document production and all sorts of wonderful things that I inflict on people. And during that time, I was wondering whether or not there was a way, to me, it's all about the evidence, because we litigate and evidence is really important, and the accuracy and the truthfulness of the evidence is important. And so my thought was, how can we wind up creating digital evidence in a manner that its statefulness can be testably reliable over time? And so I wound up developing some interesting trusted timestamping technology. You can look up the patents, but I have a failed startup to show it and the scars in the back to prove it. But what that got me more interested in as well was the frailty of computer information to use for anything. I mean, these days you have fake videos, for crying out loud, and the possibilities for fraud and impersonation are growing exponentially. But for what we were looking for, lawyers are typically pretty backward looking. We're typically not technologically sophisticated. And back when I was starting to shout about the mutability of electronic information, I was speaking to an empty audience most of the time, and I had a lot of drink the Kool-Aid type conversations come back to me. And so most lawyers were worried about, at that point, how do you get the evidence rather than how do you assess it, how do you evaluate it? And so the only place in the American Bar Association that was dealing with this was the Information Security Committee, for crying out loud. So I joined the Information Security Committee, and they hated me enough to make me a vice chair of the committee. And then they hated me even more, and they put me as a founding chair of the e-discovery committee. And then they decided that perhaps they wanted to send me out again, because I'm a loudmouth, and become the founding co-chair of the American Bar Association's IoT committee, because I started making noise about security and IoT, of course. And then because it became a very big moneymaker for the ABA, they asked me if I would come back and actually chair the ISC after 16 years of membership. And I said, okay, you can have the IoT. I'm back at ISC. And that's pretty much what I do. I chair the security and privacy practice here. I practice on both sides of the V. So my comment to most clients, and I say it not even half jokingly, is you can see me now or you can see me later. It's going to be orders of magnitude more expensive if you see me later, or my proxy, someone like me. So I am a plaintiff's lawyer who can advise clients on how they're going to be sued. Let me tell you how I'm going to be creative. Let me tell you how I'm going to get my forensics guys and look at your information infrastructure, your cybersecurity infrastructure, and how I'm going to poke holes in it and show how you don't have commercially reasonable security. And that's part of my job. The other part of my job is bringing lawsuits. Right now, we are recent case. Well, IHG had a data breach a couple of years ago. We're suing them. PDQ had a breach. We're suing them. We're involved in what are we involved in as well? There are some others that we're involved in. We can talk about that in another time. But anyway, so I live on both sides. I like advising clients on how to prevent problems. It's a lot of fun because it's an exercise in creativity that draws from my plaintiff's background. So anyway, so much about that. So I chair the privacy and security practice at Mandelbaum, but I have this fascination with IoT devices and objects, and I think that quite apart from what's going on with Facebook and Marriott and Equifax, this I think is the tsunami waiting to happen in the legal area. All right, and with that, let me start. And stop me if you have any questions. Let me make sure I can. There we go. So here we go. Connected, smart, embedded thingies, whatever you want to call it. So let's start with the commonly understood precept that you need to have commercially reasonable security. Companies offering technology, goods, and services should provide commercially reasonable security. And we can extend that belief. We can presume that belief extends to connected and smart devices and objects. But wait. So what is commercially reasonable security? I couldn't tell you what commercially reasonable security is right now. I might be able to guess at it and be able to advise at it. But in the end, if somebody's talking about commercially reasonable security, you're talking about a jury determination in a lawsuit, after which you spend at least $250,000 to get yourself out of hot water. So, and typically to be a class action. And we'll talk about that a little bit as well. So, instead of looking at commercially reasonable security, what I look at is how do you make yourself defensible, right? The idea is if you can make yourself defensible and show some good faith, you're 3/4 of the way there to making a class action lawsuit either fizzle or not be brought, right? So let's keep going here. Come on. All right. So my current thought that's running through my very, very small brain is that security is part of functionality, right? It's not a separate unit. Why is that? Because let's look at insulin pumps, for example. There are problems with the Medtronic insulin pump. CERT came out with an advisory. The provenance of Medtronic's being able to admit to this is quite interesting, but what the problem is that it was just basically very, very, very weak or no security between the remote control and the device itself, which permitted someone to easily hack into the device and change the dosage parameters, right? So if you're walking around and you think you need X amount of insulin in your body, if someone wanted to do this, they could. Now, will they do it? Have there been reported incidences of this? No. But, walking around with a hand grenade is not a safe thing to happen, in my view. And so, to me, the security is equivalent to functionality, right? So the pros are, why is security part of functionality? Because it is. I mean, to me, it's clear. Perhaps to others, it's not. So, here's the intended or the proper or the advertised or the implied functionality. Depends on commercially reasonable security. And if you have to start litigating that, that's going to be expensive, and your potential for liability is extremely high. So, and again, security vulnerabilities that causes a device or an object to malfunction or cease functioning is a functionality component. Why? Because if it stops functioning, guess what? I don't think you can divorce the two, but people have, and I think that manufacturers in large part have done this. Because when you outsource it and say, okay, this is just something we need to do, we're going to send this to, some developer out in Uzbekistan or whatever, you're not perhaps taking the same care that you would in constructing the device itself and taking the same quality assurance steps that you might otherwise take. So what are the cons? Okay, the device functions without security. I turn it on, it works. Heck, what do I need security for? The convenient explanation is security is not functionality. And when I go to RSA in a couple of weeks, I know I'm going to have this argument probably for an hour after one of my presentations, because that's what I do, because argue. And it's not our problem, it's outsourced. We have an indemnity. We're insured, right. With a mass tort or class action, you have 1 million of these devices out there, your insurance will be eaten up before you can blink an eye, right? So don't worry, the device will fail out of warranty before anyone notices. So they won't be able to come back with that. That doesn't necessarily wash from a legal perspective. And by the way, safe and secure are relative terms, all right? But let's talk about commercially reasonable security, because that's really where the rubber hits the road. So IoT device characteristics from my perspective, there's ubiquity. There's a number of devices. I use Sagan Squared because I once saw him present at my sister's graduation at Harvard, where he did talk about millions and millions. So lots of these devices are going to be out there. They're monocultural. They're clones. They're exact identical units, or whatever, however you want to talk about it. They're immortal, all right? Or they could be immortal. And they're either centrally controlled and monitored, okay? So there's a remote management interface around there somewhere, or they're soon to be orphaned, okay? Which will happen. Think about Logitech's devices, that they're IoT devices that they keep trying to take off the market, and they keep failing because they keep getting sued. So you have either an abandoned remote management interface or no remote management interface at all right? So it's feature or a bug, I don't know. We'll talk about that. So does the end of the device or object function life match the IoT utility functionality? So does the functionality of the device match the device, the firmware that's embedded in the device? So think about, at one point I was talking about flaming toasters. So you have a connected toaster, and the toaster gets updated, and all of a sudden the manufacturer either goes out of business or decides that, well, it's really not worth it anymore, and maybe sends an email if there's some sort of authentication that says, we are no longer supporting this toaster. Don't use it. But guess what? Toasters last 10 years. This code probably go obsolete in 5. What do you do then? You're going to tell people not to buy the toaster? You'll probably get sued for that. You're going to let people use it and not update it? You'll probably get sued for that. What's the answer here? So, why should we even care? Because there's a mismatch, all right? And the mismatch is where you'll see some liability ensue. Oops. Okay, wait a minute. Where were we? Stop. Okay. So IoT use cases, and this is where I look at how where liability can ensue. So you have high volume, low value devices. Let's say your Nest devices are fairly low value, but they're extremely high volume. You say, well, yeah, if we get sued by one guy, it's not a real big problem. Why? Because what are they going to do? Oh, we'll lose $30,000, $40,000, or maybe $1 million in personal injury that might happen because of a device failure. But hey, you know what? We make a huge amount of money. We're not going to worry about it. Problem with that is that there are 1 million of these out there. And so either there's going to be 1 million cases or a class action, or what we call a mass tort, in which case you'll have all of those single events aggregated into one lawsuit, and that will probably take about 2 or 3 years to resolve, after which there will be a huge settlement amount that'll be divvied out to the various plaintiffs who have signed on to the lawsuit and opted in. And so your high volume, low value doesn't help you. So cheap devices are as much on the hook, if they're ubiquitous, and they will be, as high volume cases. Then you have low volume, high value, industrial and municipal type of IoT devices. Medical device management, maybe infrastructure management. And then you have high volume, high value devices, such as automobiles, and perhaps some, I would even put that as connected construction equipment at this point, right? There's a lot of construction equipment litigation out there for product liability and for personal injury. can add connectivity to them, and you have another way, you have another vector, you have another means to file a lawsuit in the event of a failure. And don't think, yeah.
So this question, so you're looking at like even the IoT connected cranes that fall off buildings in New York, that some have been manipulated. That's the sort of stuff you're talking about.
Sure, I'll call the bar group, and I'll have Andy look at the code. I'll get the code discovered, and I'll look at the source code, and he'll tell me where the failure is. You bring up a good point though, and this is where one of the problems, I think, that one of the inherent problems with IoT devices is that there's no event logging. So in the Toyota rollover, in the Toyota unintended acceleration cases, the plaintiff's lead counsel was able to obtain the uncompiled source code in the ECM, the ETM, the electronic throttle control module. I think it's an ECM that it's called. And this is the bar group, and they came out with a 600-page report on what they found. And what they found was something called, what was it called? It was function death. And so function death, I looked at the term and I said, function death. That's an interesting comment. And what they found was that function death is equivalent, I guess, to a blue screen, right? Where the unit, it just failed. It just stopped. The problem is that you can't reboot the car at 70 miles an hour. And you would think, oh yeah, we found the defect. Therefore, we can get huge amounts of money in recovery. But no, guess what? What you have to do in law is not only find the defect, but you have to say that the defect caused the accident. And guess what? There was no logging for that. So there was no connection between the potential for function death and the actual unintended acceleration. You can argue whether or not logging or auditing is an important component of IoT function, but perhaps with what might become a dangerous instrumentality, which is a car whose firmware fails. And what do we have now? We have what, a terabyte of information stored in cars. The more information, the more likely it is, the more code, the more likely it is to fail. So maybe we do need that sort of audit logging.
Sort of a black box.
Yeah, there is a black box which records events, and the more sophisticated vehicles in the last few years have been increasing the amount of information contained in the black box. Of course, there's the Adams Family version, which is the snapshot by Progressive, which basically will lower your insurance rates as soon as they find out that you brake too hard. But there's a huge amount of information already being stored. The fact that the ECM, that the throttle control module was not audited, I think I would have argued that it was negligent and reckless not to audit that in the event of failure because of the danger that kind of failure could have caused. And I don't think that was argued, but we're here 7 years later, backseat driving.
That still gets into the DFDs on the threat model of the problem.
And you have logging requirements and a lot of best practices for all sorts of software. You might want to ask the previous speaker to add that to the list of a top 10 gap, and then you can cite it, because until it is a requirement, you will have developers saying, why would I want, go back to the days of developers saying, why would I record failed logins? I'm not going to do nothing about it.
That's right. That's exactly right.
Does it come to the manufacturer saying, you bought a car, did you buy software maintenance? You don't have to.
But
you didn't buy the software maintenance.
But that's like buying
but you're not.
Dies or breaks at that point.
But you don't buy the car. These days, you're not buying the car. You're buying the service. Everything is a service at this point.
The other thing that sort of piling on and agreeing with your comments is that a lot of engineers of real things, mechanical engineers and real electronic engineers who actually have chips, back in the old days, those folks think about flaws as the statistical likelihood. And one of the important things in security is you may very well have a malicious adversary So as you were saying, what about all the, 5 million low value products? Well, what happens if someone decides to go after them? They can trigger that flaw to do something bad in all 5 million of them. So that's another way that you have like a multiplier.
Exactly. It's an amplifier, not even a multiplier. It doesn't get better, unfortunately. So, so potential IoT fails. So you have to consider management console breaches, access to stored data is blocked. We're involved in a lawsuit right now against an electronic health records processor who is attacked by Samsung ransomware, and their practices were taken offline for 8 days, 1,500 physician practices, and just stay tuned. That's all I can say. But in any event, that's one of the problems, so you access to stored data is blocked. You're going to have a HIPAA problem when that happens, because I can show you where HHS has come out with a statement saying that a ransomware attack is presumed to be a security incident. And by the way, with a ransomware attack, how do we know that the attacker didn't suck all your information out before they encrypted the information? And you won't know until after the fact in any event. So to say, to call Mandy in and say, oh, there was no exfiltration because it was a garden variety ransomware attack. Oh, by the way, it was the first version. We've never seen this version before. Thank you very much. That doesn't tell the whole story. And what's happening is that a lot of your law firms and your cybersecurity firms are in the business of whitewashing these events. And we think that there's much more going on. Of course, I'm never a conspiracy theorist, but hey.
Of course, that's true. The other thing to consider, again, supporting what you're saying, someone could probably go around and say, those practices have how many patients, statistically, how many of them might be in a serious medical situation? You can do the math, if it's like old people in Florida or if it's whatever it is, and you could say, there were probably in those 8 days, 251 life-threatening events where those physicians may not have had access to the data they need to properly care for these people.
If you have an attack in a hospital where you can affect the electronic system that operates their elevators, people will die because they won't be able to get from their bed to the ICU or from the ICU to the operating table. Yeah. Right? It's that simple. So
good for you. I mean, it's bad for
but we have to understand this, and lawyers don't understand this. I think the technology industry does understand this, and I think I don't think there's any lack of aggressive information or informing, but I think that the non-tech industry, non-tech participants don't really want to hear this. It's a rush to market. It's a rush to monetization. So devices and sensors can't call home or each other. So your internet, you decide that you're going off the grid, but you have connected devices. But that connected device needs a serious upgrade, not because of a communications issue where it can be hacked, but because there's an inherent failure in the code itself.
Right.
What then? Right? And you don't have one of them, you have 1,000 of them. They're hot water heaters, right? If you've ever seen a hot water heater explode and shoot through I saw a picture of that once on YouTube, a video. It's really impressive. I wouldn't want to be near anything like that. Or stove, connected stove or oven, for crying out loud, all right? So then you can have the IoT ecosystem balance malfunctions or fails. You can have, whether it's an attack or just an overload or whatever it is that causes a system to just, fall over and die. It can. So your affected communities are end users. I talk about consumers and non-consumers. So many vendors in the tech industry will shield themselves with arbitration clauses and with class action waivers to protect them from those mass actions I just talked about. But the problem with IoT devices is that the effect of the failure of an IoT device is not one-to-one. It can be 1 to 1 plus who's ever else in your household that gets affected by something that explodes and causes a fire. So those people may also be able to sue. We sued, I think we had the first IoT class action in California. We sued Mattel and Toy Talk because the Hello Barbie connected doll would be sending recordings of children's voices to a back-end server, which would then be used to monetize. They were parsing the information and monetizing it. And yeah, they got a COPPA waiver from the parents, but if you looked at the packaging had 3 children, all of whom were of different racial backgrounds, at different ethnic backgrounds. And so the presumption, I presumed that perhaps they weren't all related by blood or the same family. And so, you know, the advertisement, the offering was obviously to people who weren't, who would never be able to sign a waiver, a COPPA waiver, right? And aside from the fact that they were selling the information, and think about what children talk to their toys about, for crying out loud. I mean, you know, my daddy, my mommy, they fight, they do this or this. I mean, it can get real ugly. And don't talk to me about Alexa, please. So hospitals, medical facilities, you have municipal utility services, and smart cities, for what it's worth. All right. So you consider the possibilities. I had to add some cheap pictures in here, and you know, between industrial, home, transportation, and manufacturing, lots of different possibilities. This is a 2-year-old graph, and this is the perceived downsides. Internet of Everything was trademarked by Cisco, I think. But really, threats to data or physical security were 42% said they perceived that to be the downsides to IoT devices. Not the inability of IT systems to keep up with change, not regulatory challenges, not competition from rivals, not greater price transparency, lower profit, and not job losses due to outsourcing. It was the threats to physical security. So here's where we get a little more into the legal part of this. So the size, the monoculture, the insecurity, the non-standardized coding and manufactured connected devices and services provided through them puts millions of users, IoT users, right, consumers, at a risk for serious injury or financial harm on a massive scale, because they're built for massive scale. It just, you know, to me, it's kind of obvious. Talk to any lawyer you'll talk to, and they'll talk about privacy. Yeah, I'm a big privacy fan, but I think there's more to it than just privacy problems. So, you know, right now, the FTC said in 2013 that there would be tens of billions of devices by 2020. That's now 10 months away. That's lots of billions. The statistical likelihood of any of these devices failing on a mass basis and causing a problem has to be greater than 0. And probably, I don't know what the likelihood is, but it's got to be large, or potentially very large. Let me get back with this. So here are the liability concerns. You have poor coding. Coding for the device is a one-time event, becomes obsolete, ultimately fails to work, and either through neglect or no upgrades, through faulty initial design, minimal testing the devices is unregulated, unaudited, and generally not disclosed. So what is the mean time between failure for an IoT device? Duh, right? And when is that ever disclosed to any consumer? All right, there's no regulation. There really isn't any regulation. The coding is unregulated. The coding is unaudited and subject to little, if any, quality control. There's poor and no security. I'm basically repeating what was said by the last presenter, and it's pretty clear that it's correct. There's poor and no security standards. There's a NIST standard which was spun up, a work group spun up in 2018, and they expect a standard to come out in 4 years rather. And there's no event logging. Most IoT devices have no logging mechanisms to record failure or malfunction events. So where are the concerns? You have automobiles, aircraft, medical devices, household appliances, transportation management, environmental monitoring. Think about all these sensors, right, that are in these brand new developments of hundreds of units of condos and townhouses and houses that are going to be well, they'll have embedded code in them. They're going to be embedded straight in the wall. You think they're going to be easily removable? No. They're not. Nobody's going to want to see them. They'll stick them behind the drywall, and so you're going to have to tear them apart when you find out that they're defective. but you're going to have to tear them apart in 1,000 units in this development, and perhaps in thousands of other units in other developments that bought the same one. And by the way, from a legal perspective, who is the standing to sue? And who are you going to sue? If you're in a condo, your condo association will sue, and then maybe the individuals can sue if they've had individualized damages such as personal injury, versus just repairing the damage that one of these devices might cause. Then you have energy management, communications devices, computing devices, obviously wearables, banking and finance, robotics, and AI. Does AI come to the rescue? If AI fails, you can have that single point of failure, which can cause mass problems just as easily as defective code. So artificial intelligence, to me, there's a reason they call it artificial. Toys, games, and entertainment devices. All right, so here are the concerns arising from customers by contract or users where there is no contract of sale. Lost profits, negligence, ordinary and gross negligence, warranties of merchantability and fitness. These are all causes of action that you will find in a complaint, each of which might entitle the plaintiff, to a separate assessment of damages, i.e. compensation. There's fraud, there's strict liability. Strict liability is interesting because strict liability has to do with devices that are inherently dangerous. So my question is, when does a device can a device that is normally not considered to be harmful become inherently dangerous because it now has embedded code? Construction, cranes and whatever are considered inherently dangerous. But other devices that could cause a problem may all of a sudden change in nature and be deemed to be inherently dangerous, and then subject to a strict liability standard, which is, if we find out that it happened, you're at fault, there's no intent, there's no negligence, nothing, you're on the hook. Sure.
So, something I can relate to is the milk application, where that you have a fire command system that does bad things to people. Then you have something that connects it to being remote controlled. This thing that allows it to be remote controlled, if that has problems, this other device is already inherently going to kill people.
Correct.
Now you've just made a vehicle to allow this to be a vector.
It's another attack vector.
It's another attack vector of the device.
Correct. That's correct.
So like a network device without security.
These are like remotely controlled border sensors.
Right, or just remotely, they're networked.
Yeah.
And when you say, okay, and what's the security around it? Well, there is none. It's just we connected it to a network. So that could be a example.
And you have, so strict liability.
Someone does that.
And strict liability is something that people have really not thought about. You have unfair deceptive trade practices, which is your consumer fraud. And then there's something brand new on the horizon, which really has not been litigated yet. And we're starting to look at it because I'm Curious George, and I know we're going to be able to do it. And that is, you're going to have municipalities and states suing. And what basis are they going to use to sue? Look, if you want to know what a good proxy for that is, look at the opioids litigation that's going on. And one of the reasons that a state can get involved and sue these manufacturers is on the basis of public nuisance, something that governments and municipalities can do. If I'm a state attorney general and I find that this device has hurt 10,000 people in my state, I'm going to go after that manufacturer. There's going to be no arbitration clause, no class action waiver, and I'm going to have unlimited resources to litigate this against. And then I'm going to have 49 states attorneys generals right behind them.
Like the tobacco.
It's exactly like tobacco. That's right. That, the stage is set for that, but nobody's really thought about this from within the context of IoT devices. But you've never had this mass dissemination of so many things, and that's where the issue is.
And probably the emails that those corporations have of engineers saying this would be terrible is exactly going to be similar to the smoking gun of the tobacco.
One of the patents I saw a long time ago when I was applying for mine was, and I was looking for similar art, was a patent where these guys had put in uncompiled source code. They put in the source code as an exhibit to the patent application. And I was just leafing through it, and I saw one of the remarks was, if this happens, we are F asterisk asterisk ED. This is why I want uncompiled source code whenever I do this sort of litigation, because if I can find that that's where even the developer knew that there was a failure point, a potential failure, I'm in good hands. So it goes to what you're saying. So let's look at the government here. The companies developing IoT products and services should implement commercially reasonable security. Factors include the amount and sensitivity of data collected and the cost of remedying the security vulnerabilities. But remember, I think you look at it in terms of defensible security, because again, commercially reasonable is an after-the-fact determination. So companies right now should but don't implement security by design, and I think this was discussed before. There has to be a privacy risk assessment, minimize the data collected and retained. Good luck with that attempt. Test security, but the new California privacy law is going to change that if it doesn't get changed, because the new California privacy law will basically force a company like Samsung to provide Smart Hub application capability without giving up all of your usage information, your viewing information, which currently now does. Okay, train or else pay you for it. Train employees about good security and implement access control measures. Isn't that a new concept? So the FTC does not mention, by the way, what measures are to be taken to ensure physical and personal protection from defective or malfunctioning in IoT devices. The FDA, I have a bone to pick with the FDA. This is guidance. Guidance to me is kind of worthless because it doesn't say, it says, be careful. Not, okay, and this is how you're going to be careful. This is how you're going to start doing this. And the FDA does not have the resources to take a look at all those 16,000 a day pulls and say, okay, and the way that you're going to be using these pulls in these various medical devices, by the way, which we're coding outside the United States, and we have no idea what happens. And by the way, there's no, for years, there was no regulatory review of code safety going into the device, of code security going into the device, because it's not part of functionality. It's a color, right? It's green, all right? So anyway, so as they become more frequent now, such cyber attacks and exploits can delay diagnoses and or treatment and may lead to patient harm. Thank you for stating the obvious, Food and Drug Administration, all right? It provides recommendations to the industry regarding device design. This is as of 2018. Do you know how many devices are out there between like 1996 and the current? Actually, the first insulin device came out in the mid-'80s. There's tons of them between pacemakers and pumps and other internal devices. It gets interesting. So the FDA is kind of behind the times. NIST has a considerations for managing IoT cybersecurity and privacy risks. It's out for public comment as of September. In bold, potential impact of some IoT devices making changes to physical systems, thus affecting the physical world. Well, wow. Needs to be explicitly recognized and addressed from cybersecurity and privacy perspectives. This is the first, this is throwing down the gauntlet, right? This is, you better pay attention, because when the standards come down, it's not going to be pretty if you don't comply. Many IoT devices can't be accessed, managed, or monitored in the same ways conventional IT devices can. I mean, there's a huge disconnect in understanding that this is not, this is not a computer that you can change out some RAM on if it fails. It doesn't work that way. The availability, efficiency, and effectiveness of cybersec and privacy capabilities are often different for IoT devices than conventional devices, and it means that organizations may have to select, implement, and manage additional controls, as well as determine how to respond to risk when sufficient controls for mitigating risk are not available. From my perspective as a lawyer, if I'm going to go in and advise, I'm going to ask about all these things, and I'll have my tech people with me to drill down into the deepest part of what a client is doing, so that at least we can help them get to the point of defensible security. Okay. NIST recognizes, I'm making a joke, sensory deprivation. The nature of sensor networks presents unique challenges and risks to the components. Ease of physical access. Think about your power sensors, that basically will gather the information about your usage, not only how much you've used, but when you use and how much you use. So let's look at it this way. I'm aggregating data. I can hack into PSEG and realize that in the most high demographic zip codes, that there is very little use within this cluster of devices in this zip code. So those are probably the most likely candidates for robbery, right? Or if you want to play around with the municipality, you can shut off your electrical system, perhaps, and I'm sure that can be done remotely because they can turn it back on. So I assume that if it can turn back on, they can turn your power off, especially if there's typically if there's a power outage. So detecting and preventing these attacks has historically been a problem, primarily due to the very limited processing power on these components. It may be because of the component design itself. In all likelihood, I think part of it is because you're using cheap components.
I don't know, but I think they're making reference in that line to the military model.
NIST generally has aims. NIST provides guidance to the government.
Yeah. So.
But it proxies.
Is the old idea that anything which I can turn into a focused attack, if I reject it, then it can turn into a denial of service.
Yeah.
In other words, if I can't attack you, I'll attack your sensors and make you think I'm attacking.
I'm going to kill the messenger.
Yeah. So I think that's what they're getting at. It nothing to do with privacy.
No, but it's not and it's not really about private.
Yeah. Right. Yeah. I just need to make you think that it's 110 degrees outside, and you'll react wrong.
So Google will never be hacked, right? No,
there's a thing called Google hack.
Yeah, and of course you'll never be able to hack into their Nest data aggregator, bolus of information, and decide who uses what when, right? I mean, this may be, to me, this is almost. Google exemplifies the what is it? King without the clothes. I'm forgetting the Emperor's New Clothes, right? All right, and hey, everybody says you're great. Everybody says you're wonderful, and by the way, you say you're wonderful too because we are Google, and yet that arrogance may wind up causing its own issues down the line.
Has anyone attempted to defend this stuff by saying, excuse me, if you're looking for defensible security, unfortunately, our government has historically worked to implement attackable security. The NSA is always
Clipper chip.
Right? So the reason I mention this is go back to the RSA hack.
Mm-hmm.
Okay. So I happened to be working at a firm that was using the RSA tokens. And some very senior person said, I don't want this ever happening to us. And being stupid, I contradicted him and said, you don't understand. The components we are given to implement security with are broken by design. Broken. And unfortunately, when they decided to do that, there was only one organization which was capable of breaking them. And now there's a couple more. And next year there's going to be a lot more.
Yep.
So, I can do defense in depth with a bunch of for shit components and probably be okay, but I can't give you that level of assurance with the tools I'm given.
Yeah, don't build a spaceship with low bid items. That's
yeah, but in other words, as a firm, I'm just asking if you were asked to defend a firm, which would have the Chinese go in and break all their sensors, then they would say, why didn't you protect the data from the Chinese?
Oh,
because they're the Chinese.
No. Well, here you're bringing up a good point.
Yeah,
this is This is a nation state. How can we possibly protect against nation state attacks? Which brings me to insurance. So now cyber insurance is all the rage. It's been that way for about 15 years, and we love cyber insurance.
And won't pay off for active war.
Wait. And you know what case I'm talking about?
I think so.
So Mondelez, the big candy company, had a data breach and then made a claim against Zurich Re. And Zurich Re, after going back and forth, said, we'll pay you 10 million. And Mondelez wanted 100 million. And Mondelez said, no, we want 100 million. And then Zurich said, fine, we'll pay you nothing. And so Mondelez took him to court in Illinois. What was the reason for the rejection? Because it was supposedly something coming from Korea or North Korea or China that they used the active war exclusion to deny coverage under the cyber policy, which is something that nobody's every time I talk about it with somebody, it's like, oh, I can't believe that's happening. Well, guess what? We're busy telling our clients that if you don't look at your cyber insurance policy, insurance policies love to pay out claims, right? I mean, we know this for a fact. So don't give them a reason to say no. So that's one thing that little out of band for this. But anyway, so a first step approach to commercially reasonable IoT security or defensible security I'm sorry, did somebody have okay. No. For remotely managed embedded systems, they have to be sufficiently self-protecting so that they can refuse a command. That's your first step. And second, systems without remote management have to be designed to be orphaned or cease functioning after a prescribed time. The toaster stops working, all right? And we put it right on the front of the label. We say, use of this toaster is governed by our terms of service. It's printed right on the box. It says, if we find that this software becomes, after, we guarantee for 5 years, but after 5 years, we retain the option either to upgrade or to disable the software, the embedded software. If we disable the embedded software, the functionality of this toaster will also cease. Thank you very much.
Then you the other legal issue about the ability of do I own it? It's the conversation of what the carrier having DCMA on their carrier cup.
You're buying a service. That's why. You're now buying a service. No matter which way you look at it, you're buying a service.
So everything's moving, in your opinion, or should move to a service model because of the inherent liability of liability.
Exactly. So what are the theories of liability? You have negligence, ordinary and gross negligence, express and implied warranties. I can talk until I'm blue in the face about that, but it'd be boring. Fraud, strict liability, and then there's also privacy issues. All right, litigation hurdles are class action waivers. They'll fail because there are non-purchasing users who will have a right to sue. Single event cases will also may also have high value. Mandatory arbitration, it's yet undecided. Many will fail for non-purchasing users. That's why. That answers my question, I guess. I'm sorry about that. So, who are potential IoT victims and consumers? Children are going to be there. Why is that? Because that's the picture of the Hello Barbie doll. All right. And we were very happy to see that sucker taken off the market. All right. Also, my former firm was responsible for suing WeVibe for the sex toy that basically was sending usage information to the manufacturer. They sued under the Illinois Biometric Privacy Act, got a $10 million settlement, and took home $3 million. That thing was settled in 3 months, which is kind of a record. But so you say to yourself, okay, why on earth would you want information about a woman's use of a vibrator, right? Well, guess what? If I know that certain women, that there's a cluster of women in Oregon, on the western shore of, or whatever it is, of Oregon, that use these vibrators on a Sunday night, maybe I will send them sex aid advertisements through some other means, because this is monetizable information. That's the only reason I could think. Yeah, certainly it's not for performance and whatever. I mean, God knows. But this is information, and this goes to privacy issues as well.
Just in that particular case, was it proven that they were selling the data?
No, the acquisition of the data, non-consensual acquisition of the data was what triggered liability under the statute.
So they gathered it irrespective if they were currently selling it, that caused a statute issue. So they may have gathered it for future sale, but at the same time, they've already sort of broke the law.
Collecting it was enough.
Collecting.
Yep, without consent. So that's it. I want to thank you all for listening to this, and I'll take any questions that.
That was great.
Yeah, it sounds like that the presumed obsolescence seems to be a big deal around protecting yourself.
Yeah, it's scary.
So I've got to say, out of the gate, maybe I can't turn it off, but in so much time, it's done.
Yeah.
Is there anybody doing it right from a home IoT perspective?
Yeah, so like my question about, do we have a good reference model?
You know, because I think about just sort of the identifying who's using.
So your Nest system might be secure, but your Nest system allows other systems to interact with it, and those systems may not be secure. So how are you going to how do you, but you like that other system, and you're going to use it, so you're automatically exposing. You're already diluting the security of whatever the security is in the Nest system.
We know the military doesn't get it right. Think about that drone the Iranians stole simply by having a stronger signal. What does that mean? Signal strength is authentication? No.
Signal strength was the de-authentication that led to it being able to be worked out.
Well, there you go too. But yeah.
So just a couple of comments from the questions in the audience that are still online. Joe Kupitano says, awesome talk, fantastic. Ed Pardo, fantastic, excellent talk. So the people on the webinar enjoyed it just as much.
Thank you very much.
Can you share your thoughts on Alexa? You started alluding to having an opinion.
Here we go.
You and I talked about this earlier. To me, Facebook is not the problem. Google is not the problem. Apple is not the problem. Amazon is the problem. Amazon has a record of, and I'm a victim as well, of everything you do, of every transaction that you undertake. That gives you more granular information for your life. It's your digital doppelganger of whatever it is you do, whatever it is you buy, whatever it is your preferences are, when you buy it, what you buy, how you buy. Your spending patterns. You can probably deduce whether you're employed or unemployed based upon, your spending patterns over a period of time with Amazon. So, and we don't know what they're using your information for. And to me, Amazon, is, I think you may see an antitrust issue eventually coming up with some of these larger tech companies. So, do I have an Alexa at home? No. I kind of like the idea of being able to, walkie-talkie with stuff, but it's not as, I don't want to give, well, especially since I wound up suing Amazon a while back and won. There was a Kindle case. Remember, there was Amazon promised never to touch the content on your Kindle, and then wound up, because it had an unlicensed version of 1984.
Yes.
They ripped out all the 1984s out of all the Kindles. My client was a student who had all his notes written for his exam on it, just wiped out. So we sued and settled on that one. So I'm probably not one of Bezos's favorite people in the world. But it's, the idea is good, but we have no control over the information that we produce. That information you provide to Amazon, that, in my view, that's yours. If you crush your Alexa, are you going to get sued by Amazon because, you've basically disabled their ability to acquire information which is theirs? No. Your terms of service, you're going to say, you grant us a perpetual, non-exclusive, unlimited license to use the content in any which way we find. And by the way, if you have any disagreement, you have to go to arbitration, which is going to cost you more money and aggravation, because it's not going to be worth it for you to sue in a single event.
But prosecutors want that data too for like the whole third-party concept.
So yeah, and basically right now, depending upon how you characterize Amazon as an electronic storage facility, they may be covered under the Stored Communications Act or not. So the government can always get stuff. Right. I frankly, this may sound very like blasphemy, but at least the government isn't in it to make money. So I would trust the government a little bit more with my information than Zuckerberg.
They are. My personal one is waiting for the day they get everyone's geolocation numbers in New York City and then issue tax bills to all the people who are not declaring they're working in the city.
And they could. Obviously, they could. And then, but then the information.
They are in Florida 6.2 months of the year as well.
Well, yeah.
183 days.
My thought for years has been that a lot of the law has been set up with a certain rule in the law. This is illegal. But we know it's really hard to catch.
Yeah.
Like 55-mile-an-hour speed limit. But in the old days, you'd have to be doing 75 to be caught. Now, with the device in my pocket, the surveillance we have over everybody, it's zero cost to pull that information and to tell every one of you, you're all guilty.
So here's a downline to your authentication example.
Yeah.
We had a mock trial that I created a fact pattern for, where a CTO basically stole intellectual property and opened up a competing shop, and then was sued by her old shop. This woman was brilliant. So she basically disabled the login mechanism. She disabled all the logs that could show that she was either in the building or had access to computers. It just, system logs, event logs, all gone, right? She did a good job. So they couldn't pin her. Now, she never worked either evenings or weekends. She never, ever worked evenings or weekends. However, she had one of the most connected offices you can imagine. Her coffee maker, her microwave, her this, her that. And the way that what we were trying to prove is that you could either, do a forensic analysis of the device itself, or you go to the management console and subpoena them and get the usage information and find out that her machine, which was assigned to her at that IP address, was used during a time that she says she never at the office. She's here all day Saturday on December 31st, right? So there's your evidence. If you want to look at where this stuff can.
Or she had Wi-Fi turned on this device, the local Wi-Fi sensors would see that it was reaching out.
Yep. Yeah. So
even if she didn't connect, it's just going to reach out.
I have a great question from the webinar guys. This one's coming from Joe Capana. He says, you have any good or bad stories as a defense for vendors using EULAs that are being a victim? So my point is to click through EULAs, since we all blindly accept them. And his other comment is, I hope this triggers for him a war story about such topic.
Yeah, EULAs can go both ways. Is it a click through, or is it a click wrap, or is it, the click throughs are usually upheld, but if they're too attenuated, or the links are not clear, or the font is not clear enough, you may find that the disclosure was an insufficient disclosure, including a disclosure for arbitration. So, watch out for that. Something that's not really connected to security. Right now, we're seeing a barrage of ADA lawsuits based on website inability to accommodate visually impaired people.
The 508 issues.
Oh yeah, but there's no standard. This is where our government, regulations really. Deregulation is great. Well, guess what? There were supposed to be regulations that HEW, Health and Human Services, was supposed to come out with that addressed what you needed to do for making visually ADA compliant websites. But because we're in a deregulation mode, they pulled the proposed regulations last December. So there's no regulations. So there's no way to tell. And you have some courts ruling that the spirit of the ADA encompasses websites, and then you have other courts saying, no. So, in the 11th Circuit, if the statute doesn't say website, ain't covering it. Up here in New York, Connecticut, New Jersey, guess what? You're now covered. And if you don't have an ADA compliant website, somebody drops a lawsuit on you, a class action, it's going to cost you between $20,000 and $70,000 to settle.
Can you put that in context? If somebody doesn't understand, or I don't understand, you're saying that it's not 508 compliant, and what type of
Contrast, font size,
that would
navigability.
impact the individual if he was able to read the agreement? Or
That's
was
right.
it-
He couldn't, no, he couldn't read the website, not even an agreement.
Just
I look at the web,
just
I can't read.
provide access as if he didn't have a bathroom.
It's like having a bathroom, except it's the visually impairment. So,
I thought that when banks took TARP money, they were subject to the ADA for their websites.
I had not heard that, but I wouldn't be surprised. But there is a Southern District of New York case which has been followed now by a variety of other courts, which has said the spirit of the ADA requires that websites be made accommodate the visually impaired. But there's no standard. There's a standard in process, and there's an old standard. So no matter what you do, the best guess is to be defensible and try and be accessible to the standard that's now in process.
What's an ADA compliant IoT device?
I don't know. I haven't thought of it.
Because that's the thing.
You got an umbrella on it.
No, I mean the IoT device is like a 1980 PC, right? It's so therefore it's at the crawl stage of crawl, walk, run.
Oh yeah. We don't know. This is brave new world.
Yeah.
It's fun.
Wow. All right. Any other last minute questions before we wrap up again? Great. Well, thank you.
Thank you.
Thanks,
Thanks, guys. And thanks, Tom, for putting this all together.
Well done.
And hit the bathroom.